Good morning, everybody. We're just waiting for court to start. It's been starting at 8:30 every morning. I don't know what's delaying them, but we have the closing arguments in Charles Adelson's trial. I'm gonna just go turn on my pot for a cup of tea, and I'll be right back. Okay, so I guess it looks like they're starting at what, 9? But you never know. Maybe they'll just come on and start right away. Yeah, I've been really surprised by the 8:30 start time to this trial. That's really unusual, at least in New York. Most of them start at 9. Charlie Adelson, of course, had a cross that was much more subtle. It wasn't a showdown cross that people were hoping for, where he got tangled in all his lies very obviously. It was much more subtle. But I thought it wasn't good for Charlie. His story makes no sense. And this is, of course, his story that he was extorted by the middle woman, Katie McBanoa. Couldn't even say her name, right? And Georgia Kappelman caught him in multiple lies. Like, why are you writing these text messages? And then when he said, oh, yeah, she's like, you told nobody, nowhere on this tape is your extortion plot expressed by you or anyone else. And he's like, well, the one time I was talking to my dad and I whispered it in his ear. That's what I was talking about. I would have just hammered him on that. Like, how? I mean, Georgia did a little bit. She's like, how coincidentally, the one time you would have proved your case on the wires and you're whispering in your father's ear. I mean, this is a family of liars. My opinion, don't sue me, Wendy Adelson, the lawyer, who I believe knew absolutely all about this. I mean, she drove by the crime scene. How stupid can you get? They're like the stupid smart family. I don't even know if that makes any sense. But they're smart, but they do dumb things. And Charlie Adelson was caught on these wires, talking and talking and talking and talking. And his mom is like tight-lipped. She's not going to be caught talking about it at all on the wires. But he's on there yapping it up, trying to figure out if it was law enforcement. And then they're talking in code, which is easy for anyone to unravel in about a minute. Their code is dumb. Their actions are dumb, driving by the crime scene. And his defense, Charlie Adelson's defense, is dumb. So unless that one juror that everyone's talking about who's been nodding his head and along with the defense and really negative expressions, at least, towards the prosecution, if he gets on the jury, it's going to be a hung jury. But a hung jury just means that the prosecution gets to come back and do it better next time, just like they did with Katie McBanoa. Like, Charlie Adelson's story is not going to get better over time. That's my point. So if it doesn't happen this time, it will happen next time. But because this has been going on for almost a decade, close to a decade, people who are really invested in this case want to see him convicted, and they want to see him convicted now. So Georgia Kappelman has a lot of weight on her shoulders with this closing argument. People feel she didn't do a good enough job in cross because he's an accomplished liar and he's just going to lie. But if you've lived life on planet Earth a little bit, you're going to recognize Charlie Adelson's cadence, his cadence of a liar. I don't know even how to describe it. Very quick and with a quick answer to everything. And it's a very, very complicated story. So I don't see jurors loving this. I mean, at best, At best, he's going to get a hung jury. At best. I don't see this being an acquittal. All right. I'm going to check back with you when this starts. I guess it's starting at 9.
Morning, everyone can be seated.
Morning, Judge.
Before I ran the jury instructions for both the jurors and the parties, did anyone have anything to raise concerning them?
Yes, Your Honor, very briefly, and I apologize for not emailing you over the weekend.
I was about to ask why this didn't happen, but go ahead.
It's a long weekend, Your Honor. So just minor, on page 2, under 3.5B, it says to be the last sentence says to be a principal, the defendant does not have to be present when the crime is committed or attempted. It is a correct statement of the law, but I wonder if we need or attempted to be consistent because we've taken out attempted in other areas.
Right. State, do you have a position concerning this edit?
No, sir.
Very well. I don't believe there are any attempts that are a part of the charged offenses, just completed offenses. So I will remove attempted. Is there anything else?
2 more, Your Honor. One is just a typographical. On page 4, under 3.7, in first paragraph, 3rd line down, it reads information. I think it should read indictment.
Yes.
And then lastly, on page 7, under verdict, it refers 3.12. It is the standard instruction, but it refers to lesser included. And since the parties have waived lesser included, I think perhaps the first paragraph ought to come out. And
So they're arguing over the jury instructions as the
I think
defense's
that for the second
Well,
paragraph.
the first, well, I would
suggestion.
believe it would just read, you may find the defendant guilty as charged or not guilty.
Yes, that's fine. Your Honor.
All right, go ahead.
And then the second paragraph, the first sentence has a clause which reads, it should be for the highest offense on the verdict form. I think perhaps you could take out highest.
State, do you wish to be heard as to any of these other edits?
No, Your Honor.
All right, it's going to take a few minutes to go through this, which is why I wanted you to email me. However, we'll get started as soon as this is done. Is there anything else that we need to address?
Judge, the state has provided a laptop for the use in the jury room. It does not have anything on it. It does not have internet access. It's available for inspection if anyone wants to do that. But it's our thought that they would be provided with the headphones that are out here. The other equipment is already back there, and this laptop for their use while reviewing the evidence.
All right, does the defense have a position concerning this?
No, Your Honor.
Very well. It will be
Defense
sent
is like,
back.
can we
Any
get that
other
laptop
issues?
removed? We don't want them to
Nothing
hear
in
the
the state.
tapes.
I'll email you those changes, and from there, you won't need a verdict form, but we'll need 17.
What an evil, evil guy that guy is. The whole family lies so easily. It's amazing. And then, of course, his lawyer rubbing his back. I mean, that's half of what the lawyer does is deal with the feelings of his client, manage the feelings. If anyone remembers the staircase, they're offering to get him Valium and Xanax so he doesn't look too freaky for the jury, so he's calm enough so the jury doesn't think he's guilty. Amazing, all these tricks they do. They often have different, in this case, like things often have two meanings, like TV, bullet bourbon. So I wonder if there's any meaning to his tie, why he's wearing a red tie. He wore all blue on the stand. So, yeah, it looks like closing arguments aren't going to start at least till 9 o'clock. They're still messing with the jury instructions. Defense came in with some suggestions, which they were supposed to email the judge. And now, of course, they have to make the changes and distribute the instructions to the jury. So no rebuttal witnesses, it looks like, from the state. Interesting. I would have brought Luis Rivera up there again, but it's probably not necessary. Let's hope. I'm with you, Free Bougainville. Excuse me, pronunciation of your name. Throw away the key is right. They're so awful, this family. So incredibly awful. And I think people really expected a showdown on those quieter crosses. It's more like, when at a classical music concert, if they're doing something rousing, they're known to get a standing ovation. But on like a quieter, softer piece, no standing ovation. I think that's more like the cross. He didn't fall apart, but he did get tripped up in his lies once or twice. And I hope the jurors were paying attention. But it's just the way that all these lawyers question witnesses. It's so similar. It's so cookie cutter. I wish they would break out of the mold a little bit. Listen to my interview with Deputy DA John Lewin for more on that, on how they train lawyers to ask questions that they know the answer to. And most lawyers will stick to that formula. Not John Lewin. He says the important thing is to ask the questions of which there are no good answers. And I don't think there's a better cross-examiner out there than John Lewin.
Using the restroom? Okay.
For example, a question you could have asked him is, why are you so quiet? About the bump. He couldn't stop talking, couldn't stop wondering Who it could be? Is it law enforcement? Is it someone who read about the murder in the paper? Who's extorting us? He couldn't shut up. But on this extortion, and I think he said he was extorted twice, and I'm not really understanding exactly how that came together. Maybe the defense will explain it to me in closing arguments. But he's quiet and he doesn't tell a soul, and he's only talking in code that no one can understand. Like it's a nice day. That means I've put it behind me and I'm acting like nothing's wrong. It's so stupid if you've lived life. Hopefully these jurors aren't super young. If you're just tuning in, we're waiting for closing arguments to start in the Charles Adelson trial, excuse me. They just have to make some corrections to the jury instructions and we'll get going, hopefully. Good morning, everybody. Rashbaum,
And the jurors and
I think, has been excellent. His defense attorney, he's got nothing to work with. Many people think he's going to turn off the jury. I hope so. But he's not a bad lawyer, and I'm sure he costs quite a bit. Jurors are coming in. Doesn't that look like there's like a cat behind the where the stenographer sits? I think he or she is leaning down. Looks like there's a cat at the helm there. I don't think it really helped Charlie to say his whole life depended on it, because if I were a juror, that would just remind me that that's what he said on the stand in direct. He said, my whole life depends on this. If I were a juror, it just would remind me of his incentive to lie. But at best he can hope for, I think, watch him get an acquittal and me be totally shocked. I will be shocked if he gets acquitted with this amazingly lame defense. I mean, O.J. Simpson's defense I thought was pretty lame, and he got an acquittal, so. But I think best he can get is a hung jury, and then he's got to pay for his lawyers all over again, and he'll get demolished in the second trial. Prosecution will just tighten their defense up. It's not a surprise anymore. This was a total surprise. Nobody had heard this story until this trial. So I think that should he get a hung jury, he will get absolutely convicted second time around. If you're just tuning in, we're waiting for the closing arguments to begin in Charles Adelson's trial. Surprised everyone took the stand last week, Charlie Adelson. And it was like a recitation of lies. He'd obviously studied his lies, like I imagine he studied in medical school, memorized them. And he's the kind of guy to make up a new lie on the spot if he has to. Really dangerous, slimy character. And check out my Twitter. Someone posted up his history in medical school. He wasn't doing well, and how his father had to come in and ask for favors for him to graduate school. Of course, he did 3+ years after medical school for a special kind of orthodontist license. So he's getting the big bucks. He's putting in the implants. He's putting in the cosmetic dentistry. He's getting the big bucks.
Back in session. Everyone can be seated. You can pass those out. For everyone in the gallery, I just wanted to give a reminder once again, as the closing arguments are taking place, do not make any gestures, do not shake your head that you're in agreement or disagreement. Please silence your devices, and also as well, do not have any cameras that are pointed at either the jury or the litigants.
So that's the first time we've heard about shaking of heads. That obviously he's heard about the juror who is nodding along with the defense and shaking his head at the prosecution. Many people feel he's an alternate. I hope so.
about. Please get it on silent now.
Can't believe that they're allowed to have their phones in New York. We have to check them. Shout out to all the trial goers, watchers out there. I think it's absurd that they're allowed to have their phones, and this trial has been interrupted multiple times by people's phones ringing. So maybe Florida should rethink that. That's someone I hope I never come across, Charles Adelson. What a horrible human being. Hope he's in the clink for the rest of his life, seriously.
Everyone can be seated. Members of the jury, good morning. Now that the evidence has closed in the case, I am going to be giving you your instructions on the law itself. A copy of the jury instructions that I will be reading to you has been placed in your chairs. If you wish to follow along as I read to you, that is certainly your choice. If you just wish to listen as I read it out loud, you may do so as well. After these instructions have been given, the attorneys are going to give you their closing arguments. Let's get started at header 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give you. Charles Adelson, the defendant in this case, has been accused of first-degree murder, conspiracy to commit first-degree murder, and solicitation to commit first-degree murder. Charles Adelson is accused of first-degree murder in count 1 of the indictment. I will now instruct you on the circumstances that must be proved before Charles Adelson may be found guilty of first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, Daniel Markel is dead. Element 2, the death was caused by the criminal act of Charles Adelson. Element 3, there was a premeditated killing of Daniel Markel. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the defendant had a conscious intent that the criminal act be done, and the defendant did some act or said some word which was intended to, and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. If the defendant paid or promised to pay another person or persons to commit a crime, the defendant is a principal and must be treated as if he had done all of the things the person who was promised or received the money did if the defendant had a conscious intent that the criminal act be done, and he made or promised the payment in exchange for the commission or promised to commit the crime or to help commit the crime, and the crime was committed by Sigfredo Garcia and or Luis Rivera. To be a principal, the defendant does not have to be present when the crime is committed. To prove the crime of criminal conspiracy, the state must prove the following two elements beyond a reasonable doubt. The intent of Charles Adelson was that the offense of first-degree murder would be committed. In order to carry out the intent, Charles Adelson agreed, conspired, combined, or confederated with Catherine Magbanua and or other co-conspirators to cause the first-degree murder to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words pass between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. To prove the crime of criminal solicitation, the state must prove the following two elements beyond a reasonable doubt. Element 1. Charles Adelson solicited Catherine Magbanua, Sigfredo Garcia, and or Luis Rivera to commit first-degree murder. Element 2. During the solicitation, Charles Adelson commanded, encouraged, hired, or requested Catherine Magbanua, Sigfredo Garcia, and or Luis Rivera to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant do any act in furtherance of the offense solicited. The crime of first-degree murder has been previously defined in these instructions. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial, and to it alone, that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get this witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like any other witness, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, or hopes to gain more favorable treatment in her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you apply to the testimony of other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Number two, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. Number three, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Number five, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It will be my job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. You may find the defendant guilty as charged or not guilty. If you return a verdict of guilty, it should be for the offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. And there is actually only one verdict form because we're not going to introduce chaos into the case, but I will read it to you now. State of Florida versus Charles Adelson, case number 2016 CF 3036B. We, the jury, find as follows as to count one of the indictment, first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of first-degree murder. Option B, the defendant is not guilty as to count one. Count two. We, the jury, find as follows as to count two of the indictment, conspiracy to commit first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of conspiracy to commit first-degree murder. Option B, the defendant is not guilty as to count two. Count three. We, the jury, find as follows as to count three of the indictment. Solicitation to commit first-degree murder. Check only one letter choice as to this count. Option A, the defendant is guilty of solicitation to commit first-degree murder. Option B, the defendant is not guilty as to count three. and then it is to be signed and dated by the individual who will serve as the foreperson. Both the state and the defendant have now rested their cases. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Is the state prepared to give its closing?
Yes, Your Honor.
You may proceed.
May it please the court.
Okay, that's Georgia Kappelman. She's the assistant state's attorney, and she's fantastic. A lot of pressure on her to do a fantastic close after what people thought was a disaster. I didn't. Just was not bombastic cross-examination of Charles Adelson.
In jury selection, we talked about the burden of proof and how it was my burden to prove this case to you beyond a reasonable doubt through evidence. And generally speaking, the defense's job is to poke holes in the evidence and argue that it falls short of meeting that high burden. And we also learned at jury selection that the defense does not have to prove anything. But sometimes if the law enforcement investigation is so thorough and so compelling that there's really no way to poke holes in the evidence, he has to basically admit his own words, his own text messages. That stuff is undeniable, right? And those things prove that he was in cahoots with Catherine McVanois in 2013, through the murder in 2014, and all the way up until her arrest in October of 2016. He knows he can't deny that he paid the killers because of this bizarre practice he had of stapling his money. So sometimes when a defendant can't attack the facts or the law, they instead try to explain it away by saying, you can't trust what you're seeing. It's not what it appears to be. It's actually something else entirely. Often, as in this case, the individual explanation, so when you zoom in on one piece of evidence with its attached explanation, can be like, maybe. But when you zoom out and you add all these things together, this explanation, and this explanation, and this explanation, this coincidence, and this coincidence, and this coincidence, it starts making less and less sense. It starts being less and less reasonable. And when you zoom out from the defense's theory, it's really unreasonable, right? Because to find it reasonable, you have to buy a lot of things that he's selling. The most obvious of which is that because Sigfredo Garcia hated him, he and Rivera traveled to Tallahassee twice to kill someone he hated in hopes that he would give them money for it on the back end. Please think about that. To hit this defendant where it hurts, these two dudes with no connection at all to Dan Markel and without 2 nickels to rub together, rented a car and paid for gas to come to Tallahassee and stay in a hotel twice in order to kill someone that this defendant hated, to harm him. And for what? To maybe get money. Maybe he just turns him in for murder. Why not just kill and rob him if what you're after is money and there's no hired hit? Why not just kill and rob him if your motive is, we hate him? Then the bad guys don't even have any contact with him, according to his own story. They didn't threaten him. They did not beat him into submission. Instead, they sent his own girlfriend to extort him on their behalf. And without any actual contact from the bad guys, the defendant just opened up his safe and handed over his beloved money that he had saved his entire life since he was a child. He just handed it over. Take it all. And when that amount wasn't sufficient, these stone cold murdering gangsters let the defendant go on a payment plan to give him the rest of the money. They let Catherine Magbanua skim off the top each month. And never, over the next 2 years that he was being extorted monthly, these gangsters, remember that money doesn't go to the principal, that $3,000 a month. They never show up to demand the remaining $195,000 that this defendant has agreed to pay them. Then you also need to find reasonable that over the 2 years of this supposed extortion layaway plan, that the defendant continued to do what? Send these kissy faces and love texts to Catherine Magbanua. He's sending these messages to a woman who got him into this mess, and he says he didn't suspect she was involved. What? What do we know about this man? He didn't suspect she was involved. She's taking the money. He's never even heard from the bad guys. He didn't see it that way, that she got him into this mess. They grew closer after she began extorting him for $3,000 a month. Meanwhile, the defendant and Catherine Magbanua break up. She continues to maintain her direct and indirect contact with Sigfredo Garcia, the man who's extorting him, the man who murdered his former brother-in-law in cold blood. But he sees her as a friend. The kissy faces and the I love yous continue. Even after Catherine Magbanua got back together with the man who executed Dan Markel, the father of his young nephews, and a guy who's actively extorting him, this defendant continued to reach out to her over and over again to offer her favors and gifts, including a birthday gift for Garcia, and to tell her he loves her and how lucky he is to have her in his life. Lucky? Next, to find a reasonable doubt here, you have to find it reasonable that the defendant never texted or talked about this first layer of extortion. Why? According to him, because Catherine Magbanua said, let's never talk about this. So they didn't. Then you have to believe he never reported or revealed this information to law enforcement out of fear of the gangsters. And finally, you have to believe that this living in fear of death by gang members over 2 years didn't cause a change in his general demeanor that his friends noticed, but later the bump from law enforcement did. He says that's because, well, I became worried that I might be falsely arrested. So I wasn't a hot mess when I was being extorted by gang members and threatened to be killed and my whole family killed. But I became a hot mess when I started to get worried that the cops might be getting closer. And I have no real way of knowing if all this stuff sounds ridiculous to you, if it sounds reasonable to you, or if y'all just heard so much stuff that you're totally confused and can't even remember what the evidence in the case showed. But they only need to get one of you confused enough to derail this whole thing, right? So I've got to go through each thing with you. Your verdict has to be unanimous. So I want to go through the testimony, I want to review the evidence, and I want to spend a little bit more time talking about this multitude of explanations the defense has offered in an effort to really turn each piece of evidence on its head. This is Dan Markel. He is the victim in this case. A brilliant lawyer, a funny guy, a son, a colleague, a brother, a mentor, and a friend. But most of all, a father. A dedicated and loving father whose downfall was brought about by the fact that his number one priority was maximizing his access to those two little boys in the wake of a bitter divorce from their mother. And despite the defense's efforts to characterize their client as the real victim here, Dan Markel remains the only victim in this case. The only thing he was guilty of is fighting like hell for those kids. And he lost. He didn't lose in court, but he lost. This is what he looked like before this defendant hired a hitman to kill him. And this is what he looked like afterwards. The evidence has shown that on July 18th, 2014, this brilliant man was gunned down in broad daylight in the driveway of his own home. His horrific death ultimately set police down two separate paths following the two most promising leads they had. The first was to chase down that Prius that Mr. Geiger saw fleeing the crime scene. And we'll examine those efforts in detail. The second path was to ask, as we would in any murder investigation, who might want to have done this? Who would want Dan Markel dead? And within 1 hour of the shooting, before Professor Markel was even pronounced dead, this path was already pointing to the defendant. When his sister revealed to law enforcement that her family hated Dan Markel and that her brother, Charlie, had joked about hiring a hitman to kill him. And this trash talk, of course, would be meaningless had he not been killed by a hitman. So who did it appear had a motive to want Dan Markel dead? His own family. And what offense had Mr. Markel committed against these people? Refusing to let his children be taken away from him? Objecting to them disparaging him to his kids? The evidence has shown that the Adelson family was all about psychological warfare. And when all else failed, they were willing to go even further to win. I want to examine this motive in more detail and look at exactly how it's attributable to this defendant. Despite the defense efforts to minimize this, it's really clear that the divorce between Wendy and Danny was a particularly nasty one. They fought over everything, all the way from the children down to the bicycle and the tennis racket. In January of 2013, Wendy Adelson filed a motion to allow her to relocate to South Florida with the kids. They were 2 and 3 at that time. As one basis for this request, Wendy cites the wife's parents reside in Coral Springs and the wife's brother resides 20 minutes away. The children are very close to the wife's parents. Wendy Adelson also alleges in this filing that the husband has also created a hostile work environment for the wife at FSU School of Law. Wendy Adelson viewed herself as stuck in Tallahassee, a characterization which she now denies, but one which was used to describe her situation by Jeffrey Lacasse on the witness stand and also in her own pleadings in these divorce filings. In Markel's answer on page 80, he seeks continued equal time sharing in Tallahassee. He seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of the kids. Then we go to this May email from Donna Adelson to Wendy. These emails are offered as examples of how invested Donna Adelson was in this litigation and in Wendy's life in general. They reveal that relocation was a huge priority for Donna and that it was also a high priority for Wendy, Harvey, and the defendant as well. Wendy testified that her mom really wasn't that involved in her divorce proceedings. Again, these emails prove the opposite was true. On May 3rd, 2013, this email references Dan's divorce filing as, quote, his 23-page rant. She then crystallizes the importance of relocation, stating, the most important part of your divorce is relocation, in bold. I sincerely hope that your attorney understands this is your, all caps, non-negotiable. She needs to hear from you how serious you are about this and how it will benefit the children with a close-knit family support system, as well as your significantly better paying job. But on June 21st, 2013, Wendy's motion to relocate was denied by the court, with the court finding that the wife has not met her burden of proof that a relocation is in the best interest of the minor children. Like the heroine in her book, Wendy and the boys were officially stuck in this small stop on the way to what we had previously known as civilization. Wendy worked hard to try to convince you that none of this was a very big deal to her, her mother, or her brother. And she said she was expecting to win everything in the divorce. She was expecting Danny to lose everything in the divorce. She was partly right. Danny did end up losing everything, but not in court. She had already lost relocation, and her attorney had to get off the case as a result of whatever Danny was filing in court. And he was poised to really take her through the ringer with this grandma motion, the fraud allegation, and the contempt motion that was all pending. Even if he wasn't going to be successful, folks, it was going to be a very unpleasant ride for Wendy Adelson. But as we have learned, Jibbers hadn't beaten the Adelson family yet. On the stand, Wendy Adelson suggested that relocation was not a big issue for her. It was just suggested by a friend, but the other evidence in the case suggests the opposite. Jeffrey Lacasse said she was a complete mess over the litigation, especially the relocation. She wrote a book about a human rights attorney who was stuck in a small town in the Florida Panhandle because of her hapless Canadian professor husband's job at NFSU. And maybe most importantly, Wendy filed this motion for relocation. Her lawyer didn't file it without her knowing. Was the motion doomed from the start? Wendy clearly hoped not. But there were other ways to skin the cat. Here's a June email from Donna to Wendy. In response to the court order denying relocation, Donna emails Wendy, quote, it's time for action. It's time to take control of your life and not let Jibbers think he's won anything by having you remain in Tallahassee, 8 hours away from the only family you have. Let's show this F blank, 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 what will make him absolutely miserable. And later, the rest of your life, and consequently, Dad's, mine, and yes, even Charlie's, will be affected by how well you can perform/act before July 31st. You can be a good actress when you want to. I've seen you in action. You need to put on the performance of your life. Jibbers hasn't beaten the Adelson family yet. Then on June 25th, this is continued, that same email, we get a plan of action. Take a photo of the boys dressed nicely standing at the front door by the sign of a Tallahassee church. They're Jewish, remember? Then change your Facebook status to this one so everyone will see this. Perhaps a line under the photo with new beginnings in Tallahassee might be nice. How happy do you think you will be? Make arrangements to get the boys caught up with a private tutor at the Teenage Catholic Church who will come to the house to teach the young men about Jesus. If you don't have time to arrange this, I'll be happy to do it for you. Let Jibbers know that your children will be baptized in the Catholic Church, and you'll certainly invite him to the event. I've already checked this out, and the baptism can be arranged within 2 weeks. We can send out evites to Jibbers, his parents, sister, and anyone else you want to invite. 4, I'm looking into summer camp programs for the boys. We will pay for it, even if the boys end up only going for the few days that they're in Tallahassee with you. 5, register them for toddler classes at the church. I've looked into this too. Even if they don't actually go, we can show Gibbers that they are enrolled for the fall semester. And you cannot tell anyone this is an act. Take control from him. Get to him psychologically. He's going to want you to stop this. You have one final opportunity to make him angry. We want him ticked off so he realizes that he could lose control over his kids. We plan to make a financial offer to him to allow this relocation. You need to work this plan and we'll help you through it so that it may affect how much we offer him. Maybe he's willing to let you relocate if he knew his children could attend this private Hebrew academy. Or perhaps he'd like them to invite him to a Christmas party at their other Sunday school. Let's get this going now. I know you would never want to think that you didn't do absolutely everything you could to come down to your family. Dad and I have changed our lives this year to support you and assist you and the boys in every possible way. Charlie has accepted the loss in the office business income for us to do this because he loves you and wants only the best possible future for you. It's time for you to show us that you can put on the performance of your life for the next few weeks. And then on June 27th, she follows up with another email along the same lines, criticizing the judge and Wendy's attorney and adding, obviously the court isn't out to help you. It's clear since Judge Hobbs' last ruling that she could care less about anything you have to say on your behalf. You need to help yourself. You know, Wendy, most of the wars that have been fought for the last couple of thousand years have been fought over religion. These emails are such telling glimpses into the family dynamics behind this murder. This email is just an example of how relentless Donna Adelson was. And it's clear from these emails that she's conferring with the defendant on these plans that she's proposing. Charlie brought up a good point when he said that Americans were dropped behind enemy lines during World War II wearing Nazi uniforms to get what they wanted. They had a job to get done and they did what they needed to accomplish it. You have a job to get done in a very short time frame to accomplish it. If you dressed the kids up in Hitler youth uniforms and brought them down here, I could care less if it was an act of defiance that would show Gibbers that he's not in control. Why not stand up to this fucker? Why not fight? That's all this is, Wendy, an act of defiance that will put a scare into this jackass. It will infuriate him. You need to see the big picture. You need to look into the future of what a life without your only family nearby teaching in Tallahassee with Danny always in the picture will give you. It's not a pretty picture. Not everything one has to do in life is comfortable or easy. The extremism that Gibbers is already teaching the boys is nothing more than brainwashing. Religion is brainwashing. Control the masses. I don't think you realize the type of offer we're considering. We're planning on you, Charlie, Dad, and I going as high as equal parts in a $1 million offer. That's $333,000 from each of us. We're a team. We can't do this without your help. You've already lost relocation according to the legal system. Well, it is about winning and losing. We're trying to get a win. You deserve it. You deserve so much more than a life without family teaching in Tallahassee. Even though the divorce was final on July 31st, 2013, the anger and bitterness associated with this split was still festering. Litigation continued and even increased as both parties filed motions over the next several months alleging that the other was violating the marital settlement agreement, and both parties seeking to have the other side held in contempt of court. In October of 2013, Wendy filed a motion to enforce the marital settlement agreement and have Dan held in contempt. And Dan was hearing, and the defendant was hearing about all of this as it went on from his mother, as indicated in the emails and in the text messages shown here as well. Here she's telling him how terrible things are for Wendy and how it's negatively affecting his dad's health. Then later that month, when Wendy was about to make the second dumbest mistake of her life after marrying Dan Markel by buying a house in Tallahassee, Charlie says Wendy probably hasn't mentioned it to him because it's stupid. And then after he gets Wendy to pull the plug on the house, he's praised as the miracle worker that solved this problem. This text was sent on Halloween of 2013, the very day that Catherine McDaniel testified this defendant broached the subject to her of, hey, do you know anybody that could rough somebody up? The defendant was hearing about Wendy's situation regularly from Donna. Here we see Donna telling the defendant how angry at Wendy's attorney and stressed out Wendy is. That's on February 15th of 2014. And here's another text from Donna Adelson to Charlie Adelson 4 days later, discussing the details of Danny's actions and expressing how much she hates him. Here on March 4th, 2014, we have Donna planning to speak in private with the defendant while she's at the rest stop in Gainesville. She asks him to delete this message after he reads it. Although he's not with Harvey, and Harvey nor his birthday are mentioned in this text message. All that's mentioned in this text message is, I'm going to pull over at a rest stop and talk to you in private. This is the grandma motion. On March 26, 2014, less than 4 months prior to this murder, the defendant files his grandma motion, the counter motion for enforcement of marital settlement agreement on parenting issues, and motion for contempt and sanctions. Again, alleging that Wendy is not facilitating communication between he and the kids and getting after Donna personally. In this filing, Dan Markel alleges that on 3 separate occasions in November of 2013, the children informed him of their maternal grandmother, Donna Adelson, disparaging him. The boys indicate that, quote, Grandma says you're stupid. She says you are trying to take her sunshines away from her. And quote, Grandma says she hates you. Dan Markel requests the court, quote, enjoin the former wife from allowing the maternal grandmother to have unsupervised time with the children, and to impose appropriate limitations to safeguard the children from being subjected to disparaging comments about their father. Contrary to what Wendy Adelson told us, we learned this issue was taken seriously by both sides, and that Dan Markel was particularly hot at the time of his death because of some recent issues that were going on. So to the extent that there was any banana bread peace offering made, it apparently fell short of diffusing the issues within this family. This situation was a pressure cooker, and it was about to blow. As we learned, this grandma motion was never decided by the court because Dan Markel was murdered before it could be heard. Whether or not that is a coincidence in timing is up to you all to decide. Wendy told you that she and Dan were getting along pretty well at the time leading up, or the weeks leading up to his murder. But this assertion does not fit with the rest of the evidence in this case. In fact, her own court filings are completely contrary to that assertion. In addition, her boyfriend at the time, Jeffrey Lacasse, told you all that she took all of this very seriously, that she became upset every time there was a filing, and that her behavior became increasingly emotional and erratic as the time led closer and closer up to what ultimately was the murder day. According to Lacasse, she was especially concerned about the relocation issue. And Stephen Webster, he was Professor Markel's attorney, testified, told us that Markel was irate at the time of his death over two issues. The first being Wendy enrolling one of the kids in a school without consulting him, and the second one being him overhearing Donna Adelson refer to him as stupid on a recent Skype visit that he had with the boys. So this was far from the peaceful situation that Wendy was trying to sell you. Why was she trying to sell you that? Was she trying to protect her brother? She even told law enforcement at her interview on the day of the murder that she wanted everyone held accountable for this to the fullest extent of the law, unless it was her family. The defense seems to be telling you the litigation between Danny and Wendy was not a very big deal because minimizing the litigation minimizes the motive for the Adelson family to want Dan Markel dead. They even called Wendy's attorney to tell you that relocation was a lost cause. But what she actually said was, yes, I lose most of these motions, but in this case, I actually thought there was a chance because of some of the surrounding circumstances. And I thought, well, maybe they called her to say the divorce was routine, but what she actually said was this case was odd. That was her word, mainly because Dan Markel came after her personally, forcing her to withdraw from the case, which had never happened before. So what her testimony proved was that this was not a routine, run-of-the-mill divorce proceeding. It was one of her more difficult cases. And she didn't even have Donna in her ear like the defendant did. So the motive was clearly there. The question then becomes, was the defendant successful in distancing himself from that motive in your eyes as jurors? He says that the litigation had no impact on his life. The emails suggest otherwise. He's included on these texts. He's all over the wiretap, meddling in Wendy's life with Donna. Could the defendant have cared enough about his sister's marital problems to commit murder? Maybe, maybe not. But if he didn't, his mom certainly cared enough for both of them. And she was in his ear all the time. In defendant's own words, you can't have a miserable mom. To illustrate this point, I refer you back to the emails and to that phone call that I played that happened before the bump, where Donna and the defendant are discussing this boyfriend of Wendy's at that time, Dave. This call, along with the call about Wendy taking a particular job, which is also on that same exhibit, I think it states 130, was offered as examples to show you how the dynamics work in this family. Wendy appears to be the weakling of the pack. She needs to be protected. She needs to be helped. She needs to be coddled. She needs to be saved by Donna and the defendant. Donna is the overbearing matriarch who nags everyone to death about whatever it is that's currently on her. I call it the wheel. The wheel's turning all the time, right? And Wendy getting away from Dan Markel and moving to South Florida was number one on the wheel. It was the top priority in 2013 and in 2014. And this defendant fancied himself the savior of this family. Equal parts black sheep and mama's boy, he would often try to help Wendy at Donna's bidding. When a problem was perceived regarding Wendy's love life, aka this breaking up with Dave situation, shouldn't break up with Dave, Dave's a great guy, Donna enlists the defendant to go in and fix it. to solve the problem. When Wendy didn't know what was best for her regarding a job opportunity, Donna sent the defendant to fix it. And the evidence has shown that Dan Markell was a major problem for Wendy, and that meant he was a major problem for Donna, who in turn made Dan Markell a major problem for this defendant. Enter Catherine Magbanua, who had connections to a criminal element, and she presented an opportunity to the defendant to do what he does and solve this problem. On Halloween 2013, the defendant began the process of soliciting Catherine Magbanua to commit murder. Magbanua solicited Garcia. Garcia brought in Rivera. So if the seed of this conspiracy was planted in the spring of 2013, when Donna was looking into converting the kids to Christianity or making this $1 million offer to Dan Markell, it took root that summer when the relocation was denied and the defendant began, quote, looking into all options to solve the problem of Danny Markell, including hiring a hitman. And the conspiracy grew further still when Dan Markell filed that motion to preclude Donna from having unsupervised contact with the grandkids, the grandma motion. And as Wendy Adelson relayed to Jeffrey Lacoste just 5 days before the murder, she was never going to be able to move to South Florida unless something happened to Danny. This conspiracy spread when the defendant met someone who could actually get this thing done. Someone who was in a position of trust in his life, a person who had connections to the kind of people who, for a price, were willing to point a gun at a complete stranger and pull the trigger. And guess what wasn't a problem once Dan Markell was dead? Relocation. Within a couple days, Wendy and the kids moved to South Florida. She changed the names of Professor Markell's children from Markell to Adelson. And just like that, their father was erased. No more squabbles over kosher diets or visitation schedules. No more death matches over marital assets. No more small town pit stop on the way to nowhere, Tallahassee. No more Dan Markell. And this case may have gone unsolved if not for a few things. Number one was Mr. Geiger. Does anyone other than James Geiger watch out for their neighbors anymore? He heard a loud noise and looked into it because something wasn't right. His observation and description of that Prius was critical to this investigation. It was really the only clue that police had from the crime scene, other than the fact that this appeared to be a targeted hit rather than a robbery attempt. How would law enforcement even start to find a single light-colored Prius? This investigation may have gone nowhere if not for the tireless efforts of law enforcement to cull through all those records you've seen in evidence or heard referenced in this case, including the tower dump, phone records, SunPass records, iClouds, surveillance videos, and so much more, looking for needles in haystacks. And they found a few. One is Garcia's phone number, which was in that tower dump from Premier Gym. And when cross-referenced with all the call detail records of all the Adelson family members, there was a single hit. A call from Garcia to Harvey Adelson on July 1st, 2014. An ill-fated attempt to confront who he thought was his baby mama's new boyfriend, but who turned out to be the father of his baby mama's new boyfriend. Then tracking Garcia's cell phone to match, time-wise, a particular SunPass that went through toll plazas at the same time as the phone. That SunPass was identified as being affixed to a particular rental car, Prius, which led to this rental contract bearing the phone numbers of both Luis Rivera and Sigfredo Garcia. Although you're not being asked to decide the guilt of anyone on the screen other than this defendant, it's necessary for you to understand the roles that each played in order to understand how it is that Charlie Adelson fits into this conspiracy. Whatever your thoughts about whether or how much these unindicted players are involved, today's not their trial, and you're not going to be asked to decide anything other than in reference to Charlie Adelson. What is alleged is that the defendant solicited Catherine Magbanawat to commit the murder. He conspired with Catherine Magbanawat to commit the murder with her, and that the murder was accomplished with the defendant guilty as a principal because he hired and paid for this heinous work to be done. All right, let's see what happens when we follow the Prius. So following the Prius, as we talked about, leads to the rental contract bearing the name of Luis Rivera and the phone numbers of both he and Garcia. Those two led to Catherine Magbanawat. Catherine Magbanawat led to this defendant. And I want to walk through exactly how we get from this light-colored Prius fleeing the scene to the defendant. Start with Luis Rivera. The defense may seek to discredit his testimony because he's a bad dude. His status as a felon and a gang member are definitely things you should consider when you're weighing his testimony in this case. But please consider that his resume as a bad guy was precisely why he was selected to do this gruesome job. Rivera's gang status made him a more attractive candidate to do this murder with Garcia. In the hot tub in March of 2014, the defendant mentions his connection to a Cuban criminal element. Jeffrey Lacoste reported this within a couple days of the murder when he couldn't have known the ethnicity of the killer. The evidence has shown that the connection the defendant had was through Catherine Magbanawat, and the criminal element was, of course, Garcia and Rivera. And we know that at the time defendant made that statement in the hot tub, the plan to kill Dan Markel was already well in the works. That statement was made just 3 months before the killer's first trip to Tallahassee in June of 2014. The statement reveals that the defendant wasn't scared of Catherine Magbanawat and her associates. To the contrary, he was boastful. He was bragging about it. He was the big man who was going to solve his little sister's problem, make his mom proud, and get away with it because he was thinking of everything. And he later would say and call JJ that nothing was done improper and suggest that no evidence could be available to tie the killers to him or his family. And he was confident enough of this to brag about it in that hot tub setting, which he thought could never come back to him. He was untouchable. Because if push ever really came to shove, who are you going to believe? An oral surgeon or a gang member? He's banking on that. In regards to Rivera's plea deal, the actual only condition of his plea deal is to tell the truth. And what did he tell us? Catherine Magbanawat hired Garcia, and Garcia hired him to do a murder. Why? To help the lady who he understood to be the dentist's sister to get her kids. Aside from fitting with the other evidence in the case, there were a few things that independently corroborated Rivera's testimony. One is that accidental discharge that he told us took place in the rented Prius. This was a fact we didn't know before and were able to confirm upon reinspection of the vehicle. He also told us about the location and timing of the money drop on the morning after the murder at his and Jessica's residence, which was able to be confirmed or corroborated initially by phone records and now also by Catherine Magbanawat's testimony. And of course, the phone records confirm Rivera did come to Tallahassee, not just on the July trip, which we knew about, but also on that first June scouting trip or attempted murder trip. The communication records tell us a few other things too. That's the June trip. July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine Magbanawah to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine Magbanawah was consistent with traveling on her way back from Comfort Rental Car, where the first rental car was rented, to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and has a 25-minute conversation. On the stand, the defendant was asked about the use of landlines and whether he believed them to be more secure. He testified that on the call he was being asked about at that time, that he was talking about switching over to a landline because he was in a place that had bad reception. If there's bad reception in South Florida at a dental office, what about all the other mentions of using a landline that we hear on the wire? Surely he wasn't in a place with bad reception for all those calls. And why call the parents on the landline? Surely they have reception in their South Beach high-rise. In the 2 years of phone records that were examined in this case, the defendant talks to his parents on the landline 28 times, or 0.07% of the times that he talks to them. So mostly on the cell phone by a large majority. 3 of these 28 times were on the days that the cars were rented to do these trips to Tallahassee. Whether or not that is a coincidence is entirely up to you. After the killers returned from Tallahassee on that first trip, we have a couple text messages of interest. On June 8th, 2014, the defendant indicates he's still working on Dad's birthday present, and Donna indicates, "I know you'll come through." Then on July 6th, we've got Wendy Adelson with a location at or near her parents' place when she texts Dan Markell and confirms he's going to be in town for his own murder. This slide depicts the night before the second trip. We know Catherine Magbanawah and the defendant are together that evening at her place. He departs between 12:42 and 1 a.m. And then after the defendant departs Catherine Magbanawah's residence, we've got Catherine Magbanawah calling Sigfredo Garcia. So within minutes of the defendant leaving, she calls Garcia. She talks to Garcia several more times into the wee hours of that night, the last one being at 1:56 a.m. And then at 9 a.m. the next morning, Garcia calls the rental car place. Once the Prius is rented, the second trip begins. The Prius is rented at 6:15 p.m. on July 15th, 2014. There are several calls between our parties on the day that the Prius is rented. So we just talked about the night before the Prius was rented. On the day the Prius was rented, we've got these 2 calls, several calls, including these 2 calls from the defendant to his parents' landline. Garcia and Rivera then depart for Tallahassee July 16th, about 2 p.m. and arrive in Tallahassee around 1 a.m. Although this trip was only about 36 hours from the time they left Miami to the time they returned, there were 12 phone events between the defendant and Catherine Magbanawah during that time, and there were 4 phone events between the defendant and Donna Adelson during that time frame, including late into the night on the night before the murder. On July 17th, Magbanawah relayed to the shooters that this murder had to be done that day because the victim was scheduled to leave town the next day. And we confirmed that Dan Markell was in fact scheduled to leave for New York City the next morning on July 19th. It's hard to imagine how Luis Rivera could have obtained this information, if not in that pattern that we consistently observe in this case. defendant to Magbanua, to Garcia, to Rivera, and back the other way. Certainly you're not really to believe that the killers divined this information from the professor's blog. That's not reasonable. Wendy offered that Danny sometimes put his travel information on Facebook, but you learned from Agent Sanford that there was no information about this particular trip on Danny's Facebook, so they didn't get it from there. This is because, as Rivera and Magbanua both told you, this information came in the form of that letter from defendant through Catherine Magbanua. How would these two hitmen even know where to go or who to kill if they hadn't been given any kind of instruction? Catherine Magbanua said she knew the plan was to kill Wendy's ex, but she never knew his full name until after he was killed. She did, however, deliver that envelope that the defendant put in her diaper bag to Sigfredo Garcia. The paper, she knew, contained the instructions for the murder. Defendant advised Catherine Magbanua that she should not touch the envelope or open it, as he had taken precaution to ensure that his prints and DNA would not be on it, that it would be untraceable to him, and she should do the same. She was to deliver the envelope to Garcia, and that's what she did. This is corroborated by Rivera, who says Garcia had a paper with him on the first trip, and it contained a picture of Dan Markel and a printed address. On the day of the murder, we have communications between our parties as listed here, with the red line representing the time of the murder. This flurry of calls between our persons of interest demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine Magbanua, to Garcia, and back. We have Wendy getting a text message on the day of the murder about her TV repair appointment from her mother, Donna Adelson. It indicates that Best Buy is on their way over to help you with the TV sets in your living room. Maybe she didn't remember which TV was broken. At 8:20, on the day of the murder, Wendy texts the defendant, "This is so sweet." That text was deleted. What does it mean? At 9:19 a.m., there's a phone call between Wendy Adelson and this defendant that lasts about, 30 minutes? No. 18 minutes. So this is about 30 minutes before the murder when they hang up. They say they were discussing this TV that was not repairable. The TV that he gave her as a divorce present because it's cheaper than hiring a hitman. Only you guys can assess if you think that might just be a coincidence and nothing more. The Prius is at premiere at 9:16 a.m. The last phone communication between Garcia and Rivera is at 9:16. Afterwards, the phones turn off, consistent with what Rivera told you. We turned our phones off because we knew we were about to commit the murder, and they don't pop back up until, I think, about 12:30. The bus video catches them turning onto Benton Road to do the murder at 10:51 a.m., whereby they pull up right behind Professor Markel in his driveway. Sigfredo Garcia gets out of the Prius, approaches the driver's window, pointed his gun, and fired. Dan Markel raised his arm to protect himself, but it was no use. Professor Markel was executed at close range, whereby Garcia got back in the Prius and Rivera drove them away. Markel was left there to suffer and die. If not for James Geiger, there's no telling how many hours he might have suffered there alone and unaided. He fought for his life for 14 long hours before he finally succumbed to his injuries. The autopsy confirmed that he was shot twice at close range with a .38 caliber revolver, consistent with what Rivera said they brought as the murder weapon. Next, he was stripped, x-rayed, photographed, and dissected. because he had become a piece of evidence. When Garcia and Rivera get back on the road, they're on a second bus video, leaving town at 10:55. That narrows the time of this shooting down to a 4-minute window between 10:51 when they're seen turning on the Benton and 10:55 when they're caught fleeing the scene. And then we've got the 911 call from Mr. Geiger at 11:01 a.m. The first phone call that either Garcia or Rivera make after turning off their phones to do the murder. So first call after that is at 12:30, and it's Garcia to Catherine Magbanua. Magbanua assures them that they'll get their money the next day. This is the same time frame, roughly, that Wendy Adelson was visiting the crime scene. Wendy indicated that she went to turn onto Trescott from Centerville Road, observed a roadblock, and then turned around. But we learned that what she said happened could not have happened. Instead, the roadblock was all the way down here by the blue dot, I've got 2 blue dots. The one at the top left of the page there is where the roadblock was, that yellow line, 3 to 5 houses down from the scene. Trescott and Centerville is all the way down where the other yellow bar is. Visible from the roadblock that she approached and was observed doing so by Officer Brannon were multiple law enforcement vehicles, marked vehicles. There was crime scene tape up. There was a marked vehicle with an officer stationed at the perimeter. It was visible from that position that there was something going on at her kid's house, the house where they lived with their father. And what did Wendy Adelson do upon encountering this roadblock and observing that the police were present on the street where her kids lived? She turned around and proceeded to the liquor store to pick up her bullet bourbon. And the defendant says, well, this is another coincidence because she was asked to bring it to a party. Well, maybe. But the timing of the purchase and the fact that she went out of her way to go by the crime scene on her way to get the bullet bourbon should raise an eyebrow. But it's what she didn't do that's even more suspicious. She didn't ask Officer Brannon, hey, what's going on? She didn't call Danny. She didn't call the police to make any inquiries, or even the daycare to make sure her kids made it there that morning. Remember, Danny had her kids. She didn't even call the daycare. Meanwhile, our shooters are headed back to Miami. They pop up on an ATM camera at 6:45 p.m. in Pembroke Pines, Florida. And then both of their phones are consistent with being at Rivera's residence as of about 7 p.m. that night. At 8:23 p.m., Catherine Magbanua and the defendant make plans to meet up at his house. At 9 p.m., Donna texts the defendant, outside your house, to which he responds, 10 men. He told you from the witness stand that this text meant that Donna was just passing by his house on her way to Tallahassee and that they weren't meeting up. But Catherine Magbanua testified that when she arrived at defendant's house, the defendant advised her that his parents had just been there, and then he thought his mom had physically washed the money, which was damp when Catherine Magbanua received it. Magbanua finds the defendant to be carrying his gun around and in a frantic state. About the time that these two are meeting up at the defendant's house to do the money exchange, Dan Markell is pronounced dead at TMH. So he says he's going to be about 10 minutes out. Here he is, hitting at home at 9:40 p.m. At 9:46, we see Catherine Magbanua, consistent with being at Rivera's residence, and then consistent with heading toward the defendant's residence. She turns her phone off and it stays off for 11 hours. When Magdalena's phone pops back up, it's 9:44 a.m. on Saturday morning, and she's headed back from the defendant's house, or the direction of his house, toward Rivera's residence. That's the money drop location. These phones are consistent with a meeting at 10:30 at Rivera's, which is the time, date, and place that he advised us he received his money from Magdalena. At 12:13 p.m., the defendant reaches out to Magdalena. Defendant, headed to the gym. Are you taking the kids to the beach? It's so nice. Magdalena, it's beautiful, probably the pool. Defendant, nice, have fun. Ethan must be happy. This is what he's texting Magdalena within hours of her leaving, with all the money in his safe. All of the money that he stared at and loved on since he was a child. And he wants to know if she's going to the pool. This might be a good time to remind you that the jury room is not a place to check your common sense. We want you to bring it in there. You have heard two wildly different versions of how this thing went down, and they can't both be right. I mean, somebody's trying to sell you a bill of goods. You were selected with the belief that you would be able to cut through the garbage and make sense of the evidence in this case and render a verdict that speaks the truth. A major problem for the defense theory is the idea that the defendant and Magdalena broke up after the murder, but then grew closer together over the next 2 years as she was collecting his monthly extortion payments. Latin King extortion payment plans. Unreasonable of all is probably that Charles Adelson, the guy that talks so tough in the hot tub about his unsavory connections, an arrogant man of extraordinary resources, a prize fighter of verbosity, would just lay down and take this in silence. Let's review some of these love texts. Got that one. Then we've got July 22nd. They're talking about the weather. They're talking about prescription shampoo. On October 6th, the defendant says, I love you. It makes me feel good that you care about me. I'm very lucky to have you as a part of my life. What? Lucky? Lucky. He says, I love you again on 2/24/15. According to him, he's now been making payments for 7 months. He's had her on the payroll for 6 months. No Latin Kings have contacted him in any way about collecting his outstanding debt of $195,000. Yet he continues to pay and love on Catherine Magdalena without reservation and without the slightest suspicion that she might be in on this, and without the slightest concern for helping solve the murder of who killed his brother-in-law. Defendant says he believed Catherine Magdalena wasn't taking any of the money even after he put her on the payroll. Checks are going to her because she seemed broke. Defendant's explanation for all the love texts with Catherine Magdalena is that he felt sorry for her. He felt she was in the same position that he was in, being manipulated in the same way that he was. But the fact remains, folks, that she's taking his money. She's connected to the guy that's extorting him. She's connected to the guy that killed his brother-in-law. It defies logic that he would then proceed to grow closer with her. But he has to say that because he can't, there's no other way around these texts. It also defies reason based on what we know of this man, that he would take her for her word and just empty his safe into her purse and then keep paying, presumably forever, without asking any questions, talking about it all, or reporting anything to the police. Magbanua began getting checks from Adelson Institute 2 months after Markel's murder, and she continued receiving checks from that time frame up until the bump. The checks stopped happening at the time of the bump, and you should be asking yourself what that means. Why did the checks stop happening? Well, you would reasonably figure they stopped happening because the parties got spooked, because law enforcement, they suspected the bump could be law enforcement. Law enforcement might be getting closer, take her off the payroll. If defendant was being extorted, as he told you on the witness stand, why would the payments stop? Why would the extortionist care if other extortionists had jumped on the bandwagon? Why would the bump impact the defendant's existing obligations to the original Latin Kings? The defendant said he put her on the payroll at Adelson Institute at her request to help her get insurance for her kids, with the understanding that the money was being funneled through her to someone else and she wasn't actually getting any of the proceeds. She was just going to use that paycheck to assist her with getting subsidized housing or insurance, I think it was, for her kids. But you can see from this slide, which is dated June 24th, 2014, that she's texting him about getting on the payroll prior to this alleged first extortion effort. He says no problem at that time. This is between the first and second trips. She's asking to be on the payroll. So the explanation from defendant about why she's on the payroll does not fit with the other evidence in this case. So we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators. And each time we have a big event in this case, we see these call flurries where all the parties are calling each other in that structure that I talked about. It goes from this one to this one to this one. But as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the murder or if these call flurries around these key events are just a coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can be shaped like a wheel with one central hub talking to all the different spokes. Or it can be shaped like a train car, which is what we have here, where one person talks to only the car in front of them and the car behind them. Law enforcement was asking these same questions. How is this conspiracy shaped? How does it work? How does information flow through it? What are different parties' relative roles within a conspiracy? And the wiretap and bump were designed to answer those questions. Did you notice that Donna Adelson, see how the paper's folded in half? She didn't even look at the paper before she put it in her purse. She didn't think this was a process server. She knew exactly what it was the moment this man approached. And then she just goes about her business. Does she give law enforcement this valuable information that could be used to solve the brutal murder of her son-in-law? I mean, this guy that approached her obviously knows something about who killed Dan Markel, right? So surely she went straight to the cops. Nope. Instead, she goes straight to this defendant, who goes straight to Catherine Magbanua, who goes straight to Sigfredo Garcia. In that first call after the bump, Donna says she doesn't want to talk on the phone, but defendant can't leave it alone. He asks, does it involve me or other people? Her answer, well, probably the both of us. Probably both of us. He says, what's that? Probably the two of us. So you probably have a general idea what I'm talking about. He doesn't say, no, I have no general idea what you're talking about. He says, all right. He absolutely does have a general idea what she's talking about. And if they were innocent, as the defendant has claimed, and this was in fact a second extortion attempt, there is not a reason in the world why they wouldn't just say that. I got approached by another one. One came and paid me a visit today. It's happening again. In call B, the defendant asked Donna to take a picture of the bump letter and send it to him, and she refuses. Why? Are the Latin Kings going to see the text? Do you think someone is trying to blackmail you? Maybe. Could be. I don't know. No. That's crazy. That's his response. And I'm not adding the emphasis on that syllable. He says it like that. That's crazy. How is it crazy? You're already being extorted by Latin King members. Remember, doctor? It's because he hadn't come up with that part yet. In call C, defendant calls back again to tell Donna not to talk about things in the apartment or any place. Why? Why? The Latin Kings aren't in there. And she doesn't ask why, because it's obvious. She says, oh, obviously. Why? Because they might be under surveillance? Well, who cares if they have nothing to hide? Here we see the first use of code on the wire. People don't talk in code if they've done nothing wrong. People do not talk in code if they haven't done anything wrong. Defendant knows, he knows that fact, and that's why he told you we didn't talk in code on the wire. We spoke carefully. What does that mean? Careful of what? Defendant also told you under oath that he regrets that his mom randomly used the word TV in this call as part of her careful talk. The defendant got Wendy Adelson a TV as a divorce present as a cheaper alternative to hiring a hitman. Dan Markell was killed by a hitman. Then the same TV is Wendy's alibi for the murder, a service appointment that her mother set up for her from South Florida. And then on the wire, Donna says, quote, this TV is going to cost about $5. Does the defendant say, what TV? What are you talking about, since you inserted a random object into this careful talk conversation? No, he doesn't need to ask what TV, because he knows exactly what she's talking about, and he parrots it back. They asked you for $5,000? The defendant has advised you that this TV stuff is a coincidence. Is it a coincidence, or is it obvious they're referring to their conspiracy and this murder? Only you can decide which explanation is credible. The players in this case are smart. They've given a lot of thought to their preparations before this and to their explanations after. We know the seed was planted in early 2013, and it took over 1 year to come to fruition. And they really thought of almost everything. A clever TV-related alibi for Wendy, a frame job for Lacasse, and they insulated themselves by hiring Catherine McDaniel as a middleman, walling themselves off like those train cars, only communicating with the one in front and the one behind, and having no connection to the one further down the line. It's also important to note that in these first few calls, A, B, and C, that Donna Adelson describes the bump to the defendant, and she says the person that approached her mentioned an ex-girlfriend, but she does not say the name Katie or Catherine. Then, with only this very limited information, defendant calls only one of his many ex-girlfriends, Catherine McDaniel. In call D, defendant tells McDaniel that he thinks that this undercover, the would-be extortionist, said her name. We know this is true. The undercover did say Katie, but Donna had not yet told the defendant that. They only communicated in calls A, B, and C. And the only communication on those calls was that the person mentioned ex-girlfriend. On the wire, the defendant says he just called Katie, Catherine McDaniel, because she was his most recent ex-girlfriend. Well, we know that's not true because there's at least one woman that defendant will admit meets that definition between McDaniel and the bump, and that's Whitney Kick. On the stand, he told you all that all the you might not be the right Katie conversation. There's several mentions of that. Yo, I'm not sure you're the right Katie. I apologize. I'll feel stupid if you're not the right Katie. That was designed to reassure her that he was not setting her up. Once defendant meets with his mother and gets the details and the paper with the undercover's phone number, he meets up with Catherine McDaniel at Dolce Vita. If they had any evidence, we'd have already gone to the airport. Does that sound like an innocent man? Even if they bug your phone, you're still not talking about any of this. Talking about what? The cops would only bug your phone to get information about the murder. And if you don't have any, then there's nothing to not talk about. The cops aren't going to be doing a wiretap to investigate him getting extorted, which he hasn't even reported to law enforcement. So, not talk about what? Defendant discusses how he's going to start arming himself and is prepared to shoot. He told you under oath from the stand that he was being threatened and extorted by gang members for 2 years at the time that this recording was made. And now he's just starting to think about carrying a gun? Does this sound like a man that's been living in fear for 2 years? Does this sound like a guy who lays down and takes his lumps without question when threatened? Someone comes up to me asking for money in my house? He says that. Lines 23 and 24 on the top there. He says this as if it's a preposterous proposition that somebody would just walk into his house and demand money. But isn't that what happened to you? How is that preposterous? But wait, what changed? On the next page, he says, yeah, and guess what? When the fucking police show up and there's a doctor, there's an oral surgeon standing there with a dead gang member in his fucking driveway, they're not going to come down too hard on me. This is the same man who took the witness stand and swore under oath that he was a victim in this case and that he had been too paralyzed by fear of gang members to come forward and report his victimization. Dr. Adelson on this recording is the real Dr. Adelson. On the stand, he was so controlled, so knowledgeable about his case, so practiced. But there is no way to explain away his statements on this recording. When the bump happens, you get to observe this defendant in action in his role as fixer or problem solver. He's working those phones, trying to get Katie to investigate the bump and find out if it's legitimate or not, and also trying to reassure Donna that it's just the cops fishing and it's nothing to worry about. The bump is an actual recorded example of how this defendant acts when he is threatened by a purported extortionist. And how he acts is the complete opposite of how he's telling y'all he acted in the first extortion. Number one, he does not stay quiet about the bump. He talks about it a lot. There are multiple calls with Donna and Katie discussing the bump and what the next step should be. Two, he takes action. There are multiple in-person meetings with his mom and with Katie and eventually with his dad too about the bump and what to do about it. Three, he investigates the bump. He asks questions. He enlists Magbanua to find out who this is. He talks a lot about his concerns that this will not be just a one-time payment, but could turn into some ongoing problem. And four, he doesn't take it lying down. He threatens Nazi shit if these people think they can threaten his family and get away with it. He suggests that the problem might require an additional murder. Quote, if he can't do it, I'll find someone else that can. Number five, he's suspicious. He does not blindly accept the representations of this purported blackmailer that approached his mother. It's clear from the Dolce meeting that he doesn't fully trust Katie. He certainly doesn't trust this purported blackmailer that bumped into his mom. The person that represented themselves, the person that approached his mom represented himself as a Latin King gang member, right? I'm a brother of this guy that I met in Broward or whatever. And he's demanding money from her. Yet the defendant does not take his word for it that he's a gang member. He's not so in fear for his mother's life that he opens the safe and gets $5,000 more out and gives it to Katie. A pittance compared to the amount he's telling you he handed out to the first layer of extortion. Number six, he doesn't pay. He doesn't bring the $5,000 to Dolce and give it to Katie and say, go pay it. Because that's what I do when I'm threatened, I pay. He doesn't pay, he doesn't ever pay. And it's only $5,000. Instead, he analyzes and thinks through and talks about every possible scenario. Defendant says it's one of two things or one of two scenarios. One being the cops, two being someone actually trying to blackmail his family about this murder. According to him now, he's been blackmailed for 2 years. And he's talking to Catherine Magbanua. He's talking to the person that's been collecting his money all those months. But at no point does he acknowledge the first extortion in the Dolce Vita meeting. Why not? Oh, because she asked me not to talk about it. Well, times have changed. There's a second extortion effort now, and they're approaching my mother. You think I'm not going to mention the first extortion? Your people have been running their mouths, and now they've tracked down my mother. You need to go get this under control. Nothing like that. Next in the Dolce recording, defendant begins to explain how to prove a crime. The police have to put the person at the scene, not just in the car. He's reassuring her that even if we, law enforcement, can tie her or the shooters to the Prius, that we'll never be able to charge them. Because they didn't come to Tallahassee, they didn't shoot anyone, they didn't do anything wrong, and therefore they can't be held accountable. But that is not the law as the judge has instructed you. Everyone who wanted this done and did some act toward accomplishing it is guilty as the one that pulled the trigger. He's also telling her that even if Rivera has run his mouth to this would-be extortionist, his word alone that, hey, if he goes to the cops and starts singing and says, hey, Rivera told me he did this murder, that's not going to be enough. Basically, he didn't use the word hearsay, but that's not going to be enough to proceed on an arrest in this case. This person knows information. So Katie, they'll be back. Whoever it is knows information. Information about what? You had nothing to do with it. Remember that, doctor? You've been extorted and that hasn't been reported. What information do they have? You mean information that could be used to solve the murder of your former brother-in-law? If so, why wouldn't you want those people to go to the cops? Why wouldn't you want them to come forward with that information? Then the guilty parties will be held accountable. Your extortionist will be jailed without you having to do or risk anything. Next, defendant talks about what will happen if the would-be extortionist, the undercover, is picked up by law enforcement. Next thing you know, this person is singing. Other people start singing. As soon as they have him, he starts calling your name out, and then there's going to be police at your door and at my door. If you're innocent of this murder, why are you worried about the extortions telling law enforcement whatever it is he knows about the murder of Dan Markell? Defendant says he wants to pay the money. Oh, got ahead of myself. He wants to pay the money, but he's explaining to her the problem with paying is that people might keep coming back or tell their friends who will jump on board as well. He's explaining to her the problems with paying a potential extortionist. What he doesn't say, which is what you would expect if he'd been getting extorted for 2 years, is Garcia, or whoever you've been giving my money to, has obviously been running their mouths, and now they are messing with my mother. Next, he gives instructions. Say my friends have no idea what you're talking about. And frankly, I don't know what you're talking about, but the name sounds familiar of who's incarcerated. So I'm going to give you something as charity to help the less fortunate. But do not contact these people again or they're going to the police. The whole time you're talking, just say, I don't know what's going on. Only use the words help and charity. This isn't the guy described in this first extortion who just rolled over when threatened. He's in control. He's giving the orders. He's giving instructions. Why would you have to give instructions to a blackmailer about how to handle a blackmailer? Next, the defendant says, now he's fucking with his wife and he's fucking with him, and you fuck with the king himself, you better kill him because he's going to be a big problem. And he knows who you are. If he can't do it, I'll have someone else do it. Defendant testified that this means the only way to stop Garcia is to kill him. He's not talking about killing him. He's just saying he's a really bad dude, and that's the only way to kill him. The evidence shows that he's saying if Garcia can't handle the undercover, he'll get somebody else to do it. Then he says, and so help me God, they fuck with my family, it's gonna be fucking Nazi shit because this will be done. I mean, Katie, I don't care what I spend, okay? I swear to God. Defendant and I went back and forth on the stand about what Nazi shit might include, and I think we ultimately agreed that that would be killing. And then he says, I don't care what I have to spend. If you're struggling to figure out who this man is, that's a good clue right there. He's going to buy a solution to this problem exactly how he paid for a solution to the problem of Danny Markell. Here he wants to know if Garcia has any bad feelings toward him, meaning, is Garcia willing to look into this and handle this for me? Or does he still hate me because I used to date you? If defendant had really been getting extorted all along, surely he'd say something like, I've been paying all this money, I've been compliant with everything. Can you get him to look into this and figure this out? Katie, I'll go to the moon and back for you. Why? Because she did something big for him, and he's going to be indebted to her for the rest of his life. Not because he feels sorry for her, not because she's his protector. He's the protector. He'll go to the moon and back for her because they're neck deep in this conspiracy together. Somebody messes with her, they mess with him. Somebody messes with him, they're messing with her. It's the same thing. Here he's demonstrating an understanding of a rational understanding of how blackmail works. His example is that you could blackmail someone that's cheating on their wife, meaning you blackmail someone that you have dirt on. You don't go kill somebody and then go up to an innocent person and say, I killed your brother-in-law, give me money. At the end of the conversation, defendant says, you know who this is coming from? Inside. And then I don't have a slide for this, but he goes on to talk about what he will do for her. I don't have to sit here and tell you what I would do. I show you what I could do. You know what I'm saying? You know how I am. I look for things to do. You don't ask me for shit. He will do for her. I don't have to sit here and tell you what I would do. I show you what I could do. You know what I'm saying? You know how I am. I look for things to do. You don't ask me for shit.